Hi guys, it's Kathy. I hope you're doing well. Hi Michael. Michael. I hope you're feeling good today. I hope today is a good day for you, Michael. Just Michael. So we're gonna start off with some crazy court. We're gonna do it with some pro se. This pro se I think again is civil, I think. And other ones. So here we go. Stopping, I think. Is that who this is? That's who we're watching.
Okay, sir, your name for the record?
Tevin Wright. You spell it, my first name Tevin, Tevin, last name Wright, Wright.
Thank you. And your name?
Kia Duke.
Thank you. Most of the parties each appear in person. Mr. Wright, pro se, Ms. Duke with counsel. Ms. Schaffner, what's our status?
Yes, Your Honor. Father had filed a rule to show cause on 8/20 of 2025, and then on 8/26 of 2025, a modification of child support, and then on 2/17, a modification of custody, which I think the court just kind of set all those together, but we're only scheduled for an hour. And so that was just set about a week and a half ago. So obviously we have not had any time to prepare for a modification of custody. And I doubt we would finish that in an hour anyway.
All right. And what's the status of the children?
They reside with mother.
All right. So, Dad, you filed a motion for rule to show cause, correct?
Yes, Your Honor.
And a motion for modification of support.
Yes, Your Honor.
And we have not had hearings on those yet.
No, not at all. They all been getting rescheduled.
Okay. Then you may proceed. Who would you like to call as your first witness?
I don't have any witnesses. I just have,
Yourself?
yes.
All right. Can you raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth?
It will be the truth, Your Honor.
So that's yes?
I swear, yes.
Thank you. Tell me your full legal name.
My name is Tevin Kamar Wright.
Mr. Wright, you are father of, make this a little larger so my old eyes can read. Is it Carmen and Cairo?
Yes. Yes, Your Honor.
Carmen was born 5/21/23, Cairo 8/27/24.
Yes, Your Honor.
And you filed a petition to modify child support. Is there a previous support order that's in place?
Yes, it was, Your Honor.
And how much are you ordered to pay right now?
Well, I was bi-weekly at my job at Wal McLean, before I stopped working there.
So you, when the previous support order was entered, you were at Weill McLean?
Yes. I actually recently just found new employment because I just became a truck driver. I just graduated truck driving school in January.
How long was school?
It was 120 hours.
And how much were you making back at Weill McLean?
Wal McLean, when I left, I was making $20.50, I believe.
Ooh, $20.50. So Kelly Fitz goes into surgery today, guys. They're going deeper than they did the last times. So hopefully she's all prepped. She might not be. It's like 3:42 a.m. in Austin. So she might be making her way to the hospital right now, I guess. Hope she does okay.
And when did you get terminated from there?
I want to say it was kind of a little bit after I had my information posted by Kia, as far as like my social, my address, where I worked, where I lived, and a malicious attack. So, I mean, I have that right here. So with me leaving my job, I had to, anybody can open up a credit card or buy a car with my name. And it literally has my social here, my address.
I just asked, when did you leave your job?
It was in January, I want to say, the second week of January.
2025 or
2026.
So just recently?
Just recently, yeah.
Okay, and so during the time you were unemployed, you went to school and got your CDL?
No, I was going when I was working at Wal McLean. I put in my vacation days.
Okay, so either way, in the meantime, you've got your CDL
Yes.
and you just got employment?
Yes. I start next week on the 9th.
And do you know what you will be making?
Not exactly. I believe it's a 1099 position. So during training, it should be at least between 600, 700 a week. I'm not too sure.
You just don't know.
No, I'm not so sure yet. I have orientation next week, so they'll let me know. And this is a trucking position.
And you don't know if you're going to get paid by the load, by the mile, by the hour. You have no clue yet.
Not yet, no.
Okay. Do you know what mom was making?
When we had the meeting, they never really said anything about what she made, but the lady, Heather, she put down on the papers that she was going to put mom down for full time, and she wasn't even employed full time.
Okay. You can't tell me what other people said. You can tell me what mom said, but not what other people said. Okay?
Right.
So you think she put her down for full time?
Yeah, she put her down for full time.
Do you know where mom works?
No, I don't. I don't even know where mom lives either, Judge.
I can't really scroll down because it's not a window for me. It's a feed that I enter in. Like, I just enter the feed in. It's supposed to pick up the whole feed. I did this yesterday too. There we go. It's the best I can do.
Okay. Right. You're also alleging that you're not getting your parenting time. Is that correct?
Yes, that's correct, Judge.
Tell me how you guys are working out parenting time now.
We're actually not, because I had to file a police report. Officer Williams, he told me to stay away from her.
You're saying?
Yeah, you can't tell me what the officer said, sir.
Okay.
So tell me this, when was the last time you saw your children?
November 15th, before she went to jail.
Okay, before who went to jail?
Kia.
Okay, and when she was in jail, how long was she there?
I want to say maybe the first time she went, she was there maybe 6 to 8 hours. And then the second time she went was the day before Christmas Eve. And I didn't know where the children were, like my kids were at all. I didn't get a phone call that she was in jail or anything.
So you haven't seen your kids since mid-November.
November 15th.
And have you asked Miss Duke to allow you to have the kids?
No, I haven't, because it's like every time I ask her for the kids, it's always, oh, well, you don't want them, or why all of a sudden you want to get them, and then half the time I'm blocked. So if I'm blocked, I can't really contact my kids.
Has she told you no in the past?
Yes, I have messages right here.
And those are from Miss Duke?
Yes,
You want the court to read those?
yes, I do.
Bring them forward.
I'm very proud of him for
You have extra copies?
Oh, yes, I do, Judge.
bringing copies of the text messages and extra
Stay up here
copies.
for a second. Can you show those to Ms. Schaffner?
Yes.
And I can't see what he's wearing, but I'm going to pretend it's a collar. It's not. It looks like a t-shirt. Look at the back. My bad. Nothing says I want my kids back like a good t-shirt. Oh, he should be wearing a t-shirt that says world's greatest dad. subliminal messages to the judge.
My only objection is going to be foundation. There are no dates on here. It just says today, Saturday. He also has, the top that he has highlighted, he's also made remarks on there.
Yeah.
And it doesn't indicate, it's not the full, it's partial of a text.
Okay, you can hand them back to Dad.
Partial
Dad,
texts are fine. That's not illegal.
When were those from?
This was around the time Cairo's birthday, August 27th,
Of,
2025.
okay. And are those text messages between who?
Me and Kia,
And nobody else?
nobody else, no.
Court will overrule the objections, admit the text messages. The court will ignore the writing on the side.
Yeah. If not a jury, the court can ignore that, and the judge can have this guy authenticate the date and time of testimony. Come on, lawyer, do better. It's a partial text, she said. If that was real, they would have to submit the whole amount of texts from you and another person, your wife, husband, in every court case. Look, I was married for 19 years. There was a lot of text messages going on. A lot. So, of course, it's a partial text.
Just to bring those forward. What else would you like to tell the court?
As far as like my employment, I wanted to mention a police report I made stemming from this right here.
I'm going to object to relevance.
How is it relevant?
Well, like I said, I had to find new employment. I'm actually currently about to move soon, once my lease is up in June. It's not really safe for me and my children here in the city.
Why is that?
I mean, my social security number was supposed to judge by Kia. And now here I am trying to rearrange my life now. And my social has been compromised. I don't know how she got it. And it's posted online, like I have my social security number right here. And my kids are tied to me as far as life insurance. I'm a disabled veteran. And like I have a lot going on. Like the past month and a half, I've been trying to get my life together just around this. Somebody tried to open a credit card in my name. I have everything right here. My social is on the dark web now. And it's just, I've been going through a lot. And I don't think this right here is a good example that is set for my children. And also, her going to jail is that's not a good example either, because I didn't know where my children were. You know, nobody reached out to me, not even a relative, mom, dad.
Well, we're not here today on the custody part yet, because they haven't had time to prepare for that. We're here on parenting time and child support.
Okay.
So on the issue of parenting time, you last saw them in November.
Yes.
You've attempted to see them.
Yes.
And you've been blocked.
Yes.
He attempted to see them, but then his social security number's on the dark web, so he couldn't.
And is that why you filed? I mean, you filed this prior to November.
Yeah, and we were supposed to go to court back in October of 2025, and I didn't know it was going to take this long.
It got continued.
But as far as, the modification of the child support, I felt like it was a lot, being that, we didn't really agree upon that,
Because you filed that before you lost your job.
Yes, I filed that before. Yes. And I was at Wall McLean almost, I was there a year and a half. So April 9th of this year, it would have made 2 years.
So the joint stipulation that you signed, you're saying you didn't agree with that amount then?
No,
So you signed that, correct?
Y'all's social security number is on the dark web. All of you. Every single one of you. So now you don't have to go see your children today. If your children need you today. I can't. Dear, I can't come see you today. That my social security number is on the dark web. So maybe next year. We'll see how it goes. I gotta put my life back together.
it was by default because I didn't agree to it. So
What,
they had no choice but to sign it by default, being that I didn't agree to it.
okay. So you're saying you never signed that in the child support office?
Not the second one for Cairo. No, I didn't.
It doesn't matter, Bren. Still on the dark web. Your non-existent social security number is on the dark web.
But you did sign one for Carmen.
Yes.
And what do you think the child support should be?
Being that we have 2 children together, I have my own income, finances in my own place. She does too also, and $100 each child would be fair for me, or at least 80. Because right now, like I said, I'm in a whole life change right now, just off my social being compromised. Everything is just, I can't open bank accounts.
See, you have not run the numbers as to what you think the child support should be.
He can't pay child support. Judge, you're not listening. He said it at least 6 times. His social security number is on the dark web. He can't pay child support. He can't. Don't you understand? It's clear as day. Bren is notorious. He's notorious. So he doesn't need any special identification. Just 2 letters that are both equally the same. And everybody knows.
And I realize you're not an attorney, but you're still bound by the same rules.
Yes. $100 a week. I think that's fair for now.
What are you supposed to be paying now?
Everything, man. I was paying it was $8.92 every 2 weeks because I have another child. So Kia, I was giving her $442, I believe, every 2 weeks.
So $221 a week?
Thank you.
Yes.
Oh, she didn't like that. She
Anything else you want to tell the court?
spoke to her attorney.
No, Your Honor.
Ms. Schaffner?
Thank you. Is your
Not
child
here.
support order actually $203 per week, and then they add the extra for the arrearage? Does that sound right?
Yeah, I believe so, yes.
Okay. And who is your new job with?
Shy Logistics in Harvey, Illinois.
Do you have social media?
Yes.
And what's your name on social media?
Thank you, Donald. Thank you.
It's not Tevin Wright.
Is it Crash Bandicoot?
Yes.
His name is Crash Bandicoot. Now I want to play some video games. Old style.
Yeah. Petitioner's Exhibit 1. Did you post that?
Yes.
And you indicated that your base pay is going to be $52,000. Is that correct?
Yes, this is, okay, yes.
And total annual pay for your first year is projected to be $62,957 based on 55 hours per week.
Yes.
I would move to admit petitioners one.
I'm not
Any
ruining Champ
objections
for
to the court
her.
looking?
Champ is a good thing here. Like, makes people feel good when you when they get called Champ. I'm not ruining that for her. No way.
At one. Sir, do you have?
Plus, there's no way I can explain it the way I want to without using an F-bomb. So, stop trying to get me in trouble, Bren. I don't want to be demonetized, even though the F-bomb will not get me demonetized in any way.
Any objection to the court looking at this post?
Yes, I do, Judge.
What's your legal opinion?
This was a job I just got rejected for, G&D integrated. It was actually a home.
He submitted a job he got rejected for to the court. Whatever, it doesn't matter.
Daily position. So I didn't know I had to have experience. You have to have at least 6 months to a year experience to start with them. The recruiter, he called me and told me that everything was.
Can you tell me what the recruiter said? I believe your legal objection is this isn't really a job that you have.
Right. That was a job position that was everything that they sent me. I had my onboarding done and everything.
I'm going to overrule the objection. I'm going to admit exhibit one, and then I'll let you explain it. Okay.
Okay.
All right. Ms. Schaffner, you may continue.
Thank you.
What's the point?
So do you anticipate making approximately what they had offered you?
No.
There it is.
But you don't know for sure. You testified to that, correct?
Yes.
So you took a job without knowing what your pay was?
Not necessarily, but on the description it said maybe 80K a year, but first year trucking, I'm sure that's not going to happen.
Okay. So my question to you again was, you took a job without knowing what your rate of pay was going to be.
Yes.
Okay.
Oh, I just screwed up, guys. Bren cannot text comments because YouTube keeps eating them. So instead of explaining what champ means in Australia, he asked me to, so that he didn't have to deal with that garbage that he deals with every day. And I just flat out denied him. I'm like, no, I'm not doing that. I'm being stupid. I'm not doing that. I wonder how many times Bren had to type that sentence that he just typed into chat to get it to come through so T could see it. Champ is an insult in Australia. Here it means you're a champion. There it means you're an F-tard. Yep.
So they might be paying you $7.25 an hour. Would you take a job for minimum wage?
No, I mean,
So sitting here today under oath, what do you think you're going to be making? Based on the conversations you've had with your employer, based on the ad that you applied for, what do you think you're going to make? If it was up to $80,000, what do you think it's going to be?
after taxes, I'll probably make 50 grand a year.
Now you won't make 50 grand a year, sir. Your social security number's on the dark web. Oh.
Taxes are gross. What are you going to make gross?
50K.
Was it 50K before taxes or after taxes? Because you just said after taxes. And I said before
Yeah, it's a
taxes.
1099 position, so I'm going to have to pay taxes at the end of the year.
Now, prior to November of 2025, the last time you saw your children, what did your parenting time look like?
It was every other weekend when I could get them, because I was at Walmart Clan. I worked 6 days a week, sometimes 12 hours, but my regular schedule was 10 hours.
Now, have there been times where mom has asked you to exercise parenting time and you say that you can't, you're too busy?
Yes, and I was kind of.
Okay.
I had school.
I just showed you what's been marked as petitioners 2. Is that from September? Does she ask you, are you getting them 9/6? And you said I work both jobs?
Oh, yes, I remember.
Okay. I would move to admit petitioners 2.
Any objection to me looking at 2?
No, Judge.
2 is admitted.
Do you remember in June of 25 when she asked you if you were getting them and your lights were off?
Yes.
Okay, so there was another time that you couldn't get them, right?
Yes.
Okay. Was there a time in December when she said, hey, can the kids stay with you Saturday night? Are you going to be busy? Remember that?
Yes. I actually had a phone conversation with her.
And you said, I'm going to be at my aunt's house. Birthday, did they come? Did you ever get them that day?
Yes, we had a phone conversation.
T, I just gotta know. On this other planet, am I alone or is there freaking people there? I just need a few more words to finish this picture. Just wondering if there's other people around me.
We would move to admit petitioners 3.
Any objection, sir?
Oh, no, Judge.
3 is
No,
admitted.
Brad.
I thought you said you didn't have them, hadn't seen them since November 25.
That was a question, sir.
Isn't that what you testified to?
Was that from what, say that again?
December 11th.
Also, take 1 second.
Hi, Bingo Booty.
Oh, okay. Yeah, December 12th. I didn't get the kids that day.
But she asked you if you wanted them, right?
Yeah, she asked that day.
Okay.
Yeah, okay. I'm sorry. I had my days mixed up.
Now you say that she keeps you blocked, right?
Mm-hmm.
JK, thank you. Thank you, JK.
So yes. Handed you what's been marked as petitioners 4. Is that your phone number, 832-4619?
Yes, it is.
And you send her text messages. You some bum ass bitches. Y'all both get some heat coming. F you bitches for real. In June, you send her these text messages.
That's just normal bedroom
You
talk.
think everything's funny now till you won't be able to laugh again, bitch. Mark my words. You just indicated
Again.
that's your cell
That's just normal bedroom talk.
phone number.
I mean, yeah, but I never said anything like this to her. Like,
I would move to admit petitioners 4.
oh,
Any objection to the court looking at petitioners 4?
no, Your Honor.
4 is admitted.
No, Brad, not the real Brad Pitt. The Brad Pitt in our minds. The one that we think he is.
When did you tell her you wanted to sign off on your rights?
I never told her that.
Quit laughing at me. Quit laughing at
Second
me.
page says June. Bum ass bitch. F you need my money for. I hope your ass die. That's your phone number, right?
I never told her I hope she dies.
but you told him you wanted to sign off on your rights.
I never said that either.
I move to admit petitioners 5.
Any objection to 5?
No, Your Honor.
5 is admitted.
Linus. I wanted to come to Bill's stream and watch Judge Fleischer and talk to my coworker. But my social security number is on the dark web, so I can't.
Petitioner 6, November 30th. Another weekend without the kids. You said I'm in school. Right?
Mm-hmm.
So your career is more important, is what she says. And you said, it is actually.
Which page are you at again?
Second page. You said, it is actually, if I don't work, they don't have anything. Use your brain.
Yeah, I remember her telling her that.
She said, you can work and still get them like I do. You said, I actually want things out of life that didn't even make sense. You can't compare children to a career.
Am I? Hello. It's been forever. I'm sorry, your social security number's on the dark web. I'm sorry, but that means you're not allowed to see your kids anymore. That's just what it means. I don't make the rules. You just have to follow them. You can text them. You can text them once. Use those words that he said and say goodbye.
I move to admit petitioner 6.
Any objection to 6?
No, Your Honor.
6 is admitted.
So it sounds like, sir, you've had opportunity to get your kids, but you've had other priorities, correct?
Yes.
Petitioner 7. You said, given in September, given the recent threats you made toward me, that you were going to be holding off any communication or exchange of the children until the matter is addressed in the court process, right?
Yes.
Move to admit petitioner 7.
Any objection to 7? Hearing none, 7 is admitted.
So you cut off communication with.
T. Tona. Bren just said Gene was sensible. Is that what we call him? Sensible? Sensible Gene? Tell Gene his new name is Sensible Gene.
Yeah. Correct?
No.
Well, that's what you said in that last text message. You're going to wait for the courts.
I have messages where she just recently just texted me.
Now, you indicated that you are a disabled veteran. Do you receive money for that?
No, I'm actually like in the process of it, but like I just got my rating 60%, and I kind of got to hold off on that because I got to figure this situation out with my social security number.
That's no, you have not received any.
No.
Like, this could have been my divorce if we would have taken it to court. I paid him to take the kids. I bought him stuff to take the kids. I got food because he said he can't take the kids because they don't have food. Can't take the kids because they don't have gas. I dropped the kids. I would give him whatever. Please, the kids want to see you. Can you please take the kids? I will give you $50 if you just see your kids this today, just for an hour. I don't care. I bought him a carton of cigarettes once. I'll give you a carton of cigarettes. Just see the kids. They want to see you. And then, fast forward a couple of months, and I'm blocking him from seeing the kids. He says I withhold the kids from him. Wait, what? What? You think I want to keep them? I didn't ask to keep them. You could have taken them with you. You could have. No, I didn't. But that's what he's told everybody. I blocked him and alienated the kids from him. They sat there and waited and waited and waited for him to pick them up. He never showed, and I am the one that alienated him. This could be my divorce right here.
I don't believe I have any further questions for this witness.
Is there anything you want to say based on the questions that were asked?
No, Your Honor.
Do you have any other witnesses, sir?
No, Your Honor.
Let me ask you this, Ms. Schaffner. Is your client objecting to him seeing the children?
No, not at all. I mean, if you read the text messages, she wants him to see the children.
When can we get that started?
This weekend.
Dad, do you want to have your kids this weekend?
I would like to, Your Honor, yes.
Then you should start having your kids this weekend, beginning Friday.
Well, what about the Social Security number on the dark web, Judge? Are you going to get it off? If you get the Social Security number off the dark web, then he can have the kids.
Is there a way I can get them before then? Like tomorrow?
They're in school, are they not? Or
No, they're not in school. They're
They're
oh, they're young. I don't know.
Yeah, I mean, I don't know why he couldn't get, I mean, they're in daycare, which she has to have them in daycare so many hours because of the voucher system.
All right. You're not working right now.
no, Your Honor. I'll start next week on the 9th.
I'm going to leave it up to you and Mom if you can talk to her about some extra time. But as far as I'm concerned, the issue on the child support, I'm going to not make a decision on. I don't have enough information to change it at this time, sir. I'll leave the issue open until you get your new job and you figure out what you're making. But I'm not going to be able to change it or run any numbers now.
Okay.
Okay. It can relate back to when you filed it, but I've got to see numbers.
Oh.
But you can still be an ass and do those things. They're not mutually exclusive in your case. In my case, they are. But in your case, Bren, you can still be an ass. You know what? Today is my ex-husband's birthday, right? Not one of my kids knows this. They just don't. I mean, they've been told his birthday before in their lives, but they have no idea.
So I'm going to stay any decision on child support until such time as you have a job and you know what you're making.
Okay.
And you know what's going on. As far as the rule to show cause, I'm going to find that that's denied. There's not been sufficient evidence to show Mom has intentionally withheld any parenting time. Dad's ordered to begin his parenting time this Friday. If he and Mom can work something out during the week while he's off before he starts his new job so he can see them, then that's great as well. I don't know what the issue with daycare is. I don't know how that works with the vouchers. My kids are older than you guys probably, so it's been a long time since I dealt with daycare. But I'll leave that open to you guys to have a discussion right now to see if you can work out some extra time. Okay.
Yeah, because I'm trying to get as much time as I can with them
Before
because
you
I'm
gotta
going to
be
be
on the road.
Yeah, 2 or 3 weeks at a time. So,
Well, right now you have just the parenting time. You just get them for the weekend. As far as
Michael, thank you so much.
what you got here, if you can work out with Mom more time, great. Otherwise, you're going to get them every other weekend. Okay.
okay.
All right. Thank you for appearing.
Did you, the hearing on the motion for modification of custody or?
We can set that.
I gather that's why I was.
Yeah, I forgot about that. That was just filed 2 weeks ago.
Yeah.
Yeah, let's coordinate a hearing on that, while you guys are here on the custody issue, okay?
Okay.
Because you're still asking for custody?
Yes, Your Honor.
If I was going to marry anybody, it would be Bren. Because he lives in Australia and I live in America. So that would work out fine. Like, I could just hang up the phone. if I had it up to my neck with his opinions, I could just hang up the phone. I could just, mute my text messages. Because he's the whole way in Australia and I'm in America. It would be perfect.
Okay, this is cause number 46D02 2402 GU27. Your name for the record?
Wait, no, see, that won't work because if I get married again and it's long distance and I'm talking on the phone, I want to be able to slam the phone down on my husband when I'm mad. And you can't do that with smartphones because they freaking break. You can't slam them down when you're mad anymore. So if it was the 80s, maybe the 90s, then it would be perfect. Then I could marry Brett.
Jeff Anderson.
Thank you.
Carol Crum.
William Crum.
Thank you. And Ms. Schaffner is not involved in this anymore?
No, Your Honor.
Okay. Ms. Saul Matthews, what's our status today?
So, Your Honor, my client has done 4 visits with Harmony House. They've been doing the supervised parenting time over there. He should have had 10 or 6 visits prior to this court date, but the most recent visit he was supposed to have, his car broke down while he was at the Union Hall in Illinois. And the visit before that, he had an extremely high fever, and so he was basically laid up and obviously did not want to infect the child.
That would be lovely, Bren. That would be. I might even go to Australia for that.
So it does appear that from the visit notes, the visits were getting better as they, the child started from going from not being eager to visit to being eager to visit and things like that. So it does look like things have been improving. And then Ms. Highsmith is available to testify to the visits as well, just briefly.
All right, Ms. Highsmith, are you there?
I am.
I am sorry. I need to stop. I had an incident last night, and I'm just trying to coast through. But so I'm just gonna stop talking before I get myself in trouble. Thank you, V.
All right. Is your video off on purpose?
Yeah, no, I'm trying to get it. I got a new computer. Trying to figure it out. Not gonna help.
It almost looks like she may have the slider over the camera lens.
You're so great. Thank you for that.
Oh, there I am.
Okay. If you'll raise your right hand. Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth?
JK. I don't know how to tell you this. I really don't. Because I don't think you're going to believe me. But to most Americans, not me, but to most Americans, New Zealand is right beside Australia. Like touching, like right there. They're the same place. They're the same spot in the world. They're not 2 separate spots. Well, when you talk about New Zealand and when you talk about Australia, most Americans think they're one and the same physical location on the earth. I'm not even lying. I'm not. They do.
It is. Yes.
Thank you. Ms. Saul Matthews, you may ask your questions.
Ms. Highsmith, can you, you've been kind of facilitating the visits for Mr. Anderson and Ellie?
My visit supervisors have, yes.
But you were the one that originally set them up, correct?
Yes.
And have those visits been going well?
They have been going well until the last visit that he was here, which was on February 11th. he went downstairs and he told the assistant director, Megan, to cancel all visits going forward. He is visibly in an emotional state and reacting with anger. Dad tells Megan that this is not my daughter. I just paid today to see her and I'm not doing it anymore. She is not my daughter. They suggested that he speak to me and he states he does not want to speak with anyone, and then he stormed out.
Did he have,
And then,
did he have any visits that were scheduled after that?
yeah, he's had a visit scheduled every Wednesday. The first one, I believe he was sick, and then the second one, as you already stated, that he had car trouble.
So he didn't actually cancel all of his visits.
Pardon me?
So he did not actually cancel all of his visits?
I never canceled the ones that he said to cancel. I never canceled anything because I hadn't really talked to him, and you know, things like that happen sometimes, and I'd like to be able to talk to the parent to see what the heck is going on and whatever, but you know.
And then the visit that he was supposed to have the Wednesday when his car had broken down, did he attempt to move that visit to another day?
I believe he said that he was available any other day. My availability was not, I did not have any available time slots except for a Saturday, I believe 9 to 11, but his daughter had a birthday party to go to, and they didn't want to disappoint her with that.
Okay, so he did try to make up that visit.
Yeah.
Okay. That's all I have for her, Your Honor.
You guys have any questions for Ms. Highsmith?
Yeah,
I don't.
I need her to talk more. I think she might be drunk. I'm not sure though.
No.
Okay, thank you, Ms. Highsmith. Have a good day.
Thank you, you too.
If she was in my bar, I would hesitate if she asked me for a drink right now. I'd be like, hey, how's the weather?
All right. Ms. Matthews, anything else you want to put on the record?
Your Honor, at this point, my client, he's just asking that, you know, we move forward again with reestablishing his parenting time. He has been doing the visits and they had been, you know, going well. And he did have a little bit of an emotional issue, which is, I believe, related a little bit to he thinks that there may be some coaching, bad mouthing that may be going on in front of the child about him when she's in the home with Mr. and Mrs. Crum. So he was just a little frustrated with that because she was being a little bit disrespectful to him during the visit at one point. And so that was where his frustration came, but he did try to make those additional visits. So he's just looking to get his parenting time back on track.
Maria, hi, thank you. Okay, Bren, I'm predicting that Bobby is going to show up in 18 minutes.
Any other evidence you want to put on?
Not at this time, Your Honor.
Who'd like to talk? So just raise your right hand. Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth? Thank you. Tell me your full name.
William Edward Crum.
Which Crum, you heard Ms. Highsmith,
Correct.
and you heard what Ms. Matthews is requesting on behalf of her client.
I have heard, yes.
And what would you like to tell the court?
I'd like to say in regards to what was just stated, Ellie, we don't reverse her when the phone calls come in from her dad. Matter of fact, she doesn't want to take the calls, but we told her she must take the calls. And the calls are hard on her because she actually gets up and moves around the house instead of staying put and talking because she does not want to have conversation. And so the biggest problem there is, I think, if we would have some conversation between adults instead of Mr. Anderson strictly using his young child, and I feel an adult status way, I think things would be a lot better.
You've taken her for visits,
Yes.
and without telling me what she says, how is her behavior before the visit?
She's playing, usually, a lot of times she'll be watching television, she'll be on the couch. She, right now, for the past 2 or 3 weeks, she's been doing a lot of headstands and stuff in the living room, and so she's just basically a normal child up until that point.
And how does she do after the visit?
That's how I spend my nights too. Headstands in the living room.
With Dad?
I'll say good, sometimes a little reclusive, but nothing major.
Okay. And in response to Ms. Saul Matthews asking that Dad get back to just regular parenting time and regular relationship with his daughter, what's the response to that?
No ants.
My personal feel is, I think it's the best thing for a child and parent to have that bond and be able to get back together. But there still are things that I see that I feel are a little detrimental as far as the interactions of the father with the child yet at this point.
And what are those?
Well, those basically he'll get loud over the phone, or a lot of times he'll strike out in a manner of telling her that he wants to end it with her. He says, when you're 18 or 21, you can look me up. Things of this nature is what she hears from him.
And so do you think he should go back to just regular parenting time at this point, or do you think we need to continue the supervised parenting time?
That's, to me, that's a tough question. Like I say, I'd like to see any family come together, but I think, yes, I think there still should be some supervised parenting time in place.
Ms. Matthews, do you have any questions for this witness?
No one would cheer louder than me. I would be so happy.
No, Your Honor.
My cow.
Ms. Matthews, why should I jump right back into last time we were in court? Mr. Anderson didn't like what the court was saying when I was trying to give him exactly what he was asking for. He behaved in a manner that I've thrown people in jail for. I did not throw Mr. Anderson in jail because...
Do it, Judge. Do it for Kelly. Kelly is in surgery today, so she can't make it. Come on, Judge. Throw him in jail for Kelly. Do it for Bobby, too. Bobby loves when people go to jail. He just loves it.
Quite frankly, I wasn't sure he would even show up for a parenting time. So he has at least done some of that. But it sounds like the temper and the anger lashed back out again after the last visit.
Your Honor,
Why should I?
Well, Your Honor, he's not doing that in front of the child. That, I think, is what the difference is here, is he's lashing out at adults. He's not lashing out at the child. There was no evidence.
Wait, didn't she say, he said, that's not my daughter. She's not my daughter. I have to pay for her, but she's not my daughter. He didn't say that in front of the child? Didn't he say that right at the visit? Because it was a supervised visit. He went on a supervised visit. Then he said to the person who was supervising the visit, that ain't even my daughter. She's not my daughter.
That Ms. Highsmith brought up as far as him being angry with the child or lashing out at the child. He doesn't behave that way with his child. And
holy moly, guys. Kit Kat, how are you? Guys, we're seeing so many old faces in here today. It's really good to see you. It really is.
If the Crumbs are asking that he continue with supervised parenting time, I would be asking for them to at least pay half of the cost of that. I mean, there was no evidence whatsoever that Cheryl brought up of him ever behaving in any way that was inappropriate with his child.
Any response to that?
Only response to that, Your Honor, is the fact she brings up the expense and cost involved. We've had Ellie 3.5 total years. And in that period of time, we've had no compensation for those 3.5 years. This is something we agreed to do.
Yes, you are.
When we first took on this assignment, and we stayed with that.
You said you were holding a paper map of New Zealand in your hand. You're old. You're old because nobody holds up paper maps ever.
Any response, Ms. Saul Matthews?
My understanding of the original agreement was that basically Mr. Anderson was going to get the child back when he was released from his incarceration. And I know he's been paying for the child's phone. He has been giving them money for various things. He's been purchasing clothes and all those types of things for the child. He has been providing things. My understanding is that a lot of times though, when he would provide something like that, the Crumbs would refuse to accept it from him. So if they're refusing to accept it, I'm not sure how he can force those things into their hands. And at this point, my client he wants to get his daughter back, Your Honor. He wants that relationship with her. It was him and Ellie against the world, and he just wants to get back to that, Your Honor.
What has Mr. Anderson done to address his anger and his behavior since last time?
I absolutely I apologize to the courts for my behavior, and I had some things set up with Miss Highsmith, but she's never. We were supposed to have one, and that was the Wednesday that my car broke down, the last Wednesday. So she was going to put me in a parenting class, and I thought that would help the courts quite soon, but it never got kicked off, and she didn't have time until this last Wednesday. So it just was a delayed thing that was out of my control. But Your Honor, I love my daughter so much. It's been me and her against the world, and she's kind of my whole world. And what we've been through has been a roller coaster, and a normal person to go through what I went through, I'm not sure they would hold up as good as I have. I'm still fighting for my daughter. I love my daughter. I don't believe that what has happened between me and my daughter's relationship was just from her not wanting to be with me. It was, my daughter used to cry when she first got taken, and it was incredibly hard to be in that situation. And now I just want my daughter back, Your Honor.
And have you also been doing some counseling with your pastor as well?
Oh, absolutely. Absolutely.
Are you getting the parenting class started, or what is that situation with Ms. Highsmith? Because she had some very good success with clientele that have come through this court.
Yes, she said she was going to have it for me this Wednesday.
Okay, because I've definitely seen progress with folks with anger issues, and especially folks that have been locked up and gotten out. They call it inside out dad, trying to figure out how to deal with that, as well as being a parent for the time that you lost.
No, they're not.
Is that what she was talking about doing with you, or do you know?
I don't know. She just told me that I could take, right when I first got started with her, she told me that she has a parenting class that she thinks would help. And I said, great. And then it just never transpired until this last Wednesday she had, and I actually asked about it. And then she was able to get me in on Wednesday.
So you're starting this week?
Yes.
Okay.
So, and I do know, Your Honor, that the brief window, because when it's an hour visit, so the actual time that he gets is only like 45 to 50 minutes. And that's really hard as well for him. So like in the event that you do continue with the supervisor, we would just be asking for larger blocks of time if that's possible, just so that he gets a little bit more quality time with her.
All right, because I can tell you, Mr. Anderson, You probably read the order that I wrote. At least I hope that you did. The response and behavior I got when I was trying to give you exactly what you were asking for last time, it was a little shocking to the court.
Your Honor, it was a misunderstanding because I did the thing for termination and guardianship on that court date before I hired her. And then after I hired her, I wanted her to go with for termination. So to my understanding, when I got out of jail, I come back and I get my daughter back. That's the complete whole story of it. And then when Bill and Carol started, they went from friends to not friends. That was kind of a hard thing to handle, where all of a sudden they want to keep my daughter. And that's kind of a lot. So when it happened, I was kind of in shell shock over that. And I was upset. I mean, I wanted my daughter back, and I apologize.
Okay, anything else, Ms. L. Matthews?
No, Your Honor.
All right, I'm going to take this under advisement so I can go back and review the file and then issue an order, and I will get an order out as soon as possible.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, Your Honor, may I say something?
Technically, the hearing's over, ma'am. So, okay. But thank you.
Darn it, Judge. I wanted to hear what she had to say. All right. His lawyer did a great job. His lawyer did a great job in this hearing, because you heard that judge. That judge did not like him. He was not getting nothing. I think his lawyer turned that around, because all the reports they got on him for what he did since the last hearing sucked. They all sucked. Nothing was good. And his lawyer just pulled something out of her rear, and now the judge is thinking about it again. Micah, stop bringing the ants in here. Stop. We don't want ants in here. Okay, guys, I can't help it. I really love this judge. All right? I can't help it.
Good morning, this is Judge
Hi,
Frost.
Judge
Who do I have
Frost.
calling on a phone today?
Not me, because I
Right,
can't
thank you.
hang up on you.
All right, can you hear me okay today?
Yes, I can.
I think I need your help, maybe.
All right, can you see and hear me okay today, sir?
I can see you, yes, and I can hear you fine.
Good, let's get started. This is 25 SC 5027, Gregory McEwen versus Randall Drager. For the appearances today, I have Mr. McEwen calling in on a phone. I've confirmed he can hear me and I can hear him.
All right, chat, this is what we're going to do with this case. It doesn't matter who you assign in your head. Okay? Assign one of these guys to Bren and the other one to JK. And then just picture this is Bren and JK having an argument. Australia versus New Zealand. And it'll make it much more enjoyable.
I have Mr. Drager on Zoom video, and I've confirmed we can see and hear each other, and we are live streaming since we're on Zoom for you all. We set today to touch base again because you were going to work on possibly getting the vehicle inspected, and there were some salt-related issues and transportation issues to do with that. So is there an update on whether that was accomplished, that you got it inspected, or have a plan in place?
Actually, sir, I worked diligently upon your request. I reached out to numerous shops. I really don't understand, circuit court or small claims, but we ran into a snag between the plaintiff and I that I would like to have time to explain. And at this time, I would ask that the court would consider the matter to be adjourned and dismissed upon formal motion with good cause, which I would like to explain to the judge.
Yep,
If
go
that's
ahead.
something I can even do, I don't even know.
Well, I don't know what you're going to tell me, so why don't you tell me it and then I can let you know.
Well, our last Zoom meeting, I took your advice, did everything in text. I worked diligently, spent a lot of time calling shops in the southern Wisconsin area, looking for experts in the industry. I did achieve finding 3 experts that I think the court would agree are top of their line. One of them semi-retired, but he has owned a body shop in the Madison market area the majority of his life. The second one is one of southern Wisconsin's major brokers in high-end vehicles, old cars, and parts. The third individual is just a very talented, meticulous laborer that collects old vehicles and knows a lot about them. Interestingly enough, to collate this for you,
Yet.
on February 3rd, I received a text from the plaintiff asking, have you found a shop to look at my car yet? I responded with, we will meet with you next Thursday, February 12th at 2 p.m. Please text me the address where the car is being stored. Thank you. The plaintiff responded, I work until 4 o'clock Monday through Thursday. We can meet at 5. That would be better. Let me know. I said, what time would you be available on Friday the 13th? Anytime on Friday. Who are you bringing? And then he says, you have yet to tell me the person's name and what shop they're affiliated with. I said, I am bringing 3 experts in the industry. We will be at your address you supply me with on Friday the 13th at 2 p.m. Thank you. Please send me a text with the address.
I'm just going to tell you, in my head, I assigned this guy to Bren because he was reading the text messages like this and looking down through the bottom of his glasses. And that, in my head, that one was Bren. Also, I see his face. The other guy's on the phone, and I've never seen JK's face. So that's how it worked.
He states, that is not what I asked. I replied with, I have no legal obligation to give you that personal private information. One is a longtime shop owner. The other is a broker of collectible cars. The other is very meticulous and a car collector. Please send me the address information as we have all collated for next Friday, the 13th, as you said would be available within your schedule. Thank you.
We get to see Judge Frost get slightly testy in this one, okay? All right. It's enough. It's enough to know that if you actually got into a real argument with him, he would smoke you.
He responded with, I have every right to know, I have every right to know who's coming on my mother-in-law's property and looking at my car as your experts. So yes, you are obligated to give me those names and the shops they're affiliated with. I said, so you are denying me access for my witnesses to review the vehicle without that information. Plaintiff replies, why are you being so secretive? Are these just buddies of yours? You're supposed to find a body shop expert, not a collective car, not an insurance guy, a body shop guy. That's what you told the commissioner. So I don't know where he got that information. I said, there are 3 industry experts on schedule to look at your car next Friday at 2 p.m. Yes or no? Thank you. He replied, how do I know this? You're not giving me any information. I said, yes or no, please. That's a no on your part of giving me their information. I'm trying to work with you, but you're making it way too difficult than it needs to be. It's been 3 days since your last response with me. Are you going to work with me to get this done? And that was the last response we had with each other. So I have done everything in my power, expended all my labor and energy and time. These gentlemen and I have gotten together and tried to figure out a time that we could do this. We've been very courteous to the plaintiff trying to get this done. And obviously he has denied us access.
All
So
right.
that is my cause. I mean, I don't know what else I can possibly do. It is impossible. When you mention small claims court, you mention circuit court, for any company or anybody to even want to be attached to anything today with their name on it, and to find someone that's willing to take time out of their busy lives. And nobody wants their personal information given to someone they don't know. Not going to give them their names and phone numbers. That's ludicrous. They're experts in the industry. That's all anybody needs to know. We're gonna, like these gentlemen said, geez, we're showing up. We're gonna spend 10 minutes looking at a car in a garage. You know, what are we gonna do? Who is this guy? You know, what's his problem? And it's just been a struggle on my end. It's just been, I'm at wit's end. That's why I'm asking for this just to be dismissed. I've done everything I possibly can to satisfy this customer. I mean, you can see subjectively the last time we were in court that I offered to promptly pay the difference, which I had the jobber look at material list, and I wrote him a check the next day and sent it certified mail to prove that I did for the balance that the last judge, you know, ordered that I pay because of my suggested information to him.
Judge Day does not stream, so I couldn't get the last time they were in court with each other.
And I've done everything I can to get this past me, and it's eating up just a lot of labor and time, and I don't know what I'm supposed to be doing here to try to satisfy this. This car is.
I'm sorry, what did you pay?
Pardon me?
You just said you paid something. What did you pay?
Yes, right. The last time we were in court, I had my jobber, which is my paint supplier, build a quote of an invoice of all materials that had not gone on his car. And I reimbursed him with a check for that difference out of the suggestion of myself, and sent that check certified mail to his household.
Sure.
I mean, that was just out of my goodness of my heart to do it too. Here's
okay.
I gave him his gallon of paint back. I gave him his materials money
See,
back.
that is a saint, guys.
I've done everything I possibly
Let me
can.
turn to Mr. McEwen for a little bit. Mr. McEwen.
Bobby is 6 minutes late with the clock in my head.
I guess I'll first ask, is Mr. Drager's summary correct that you were not willing to agree to a date and time until he provided you information that you were requesting?
All Your Honor, it's my mother-in-law's property. I don't know who. All I wanted to know was a legitimate shop. That way, I could look them up on the computer to make sure they're legitimate. I thought my request was fair. Who am I? I don't know if he's just going to bring his buddies or, evil thoughts, bring an arsonist or somebody to steal my car to make the evidence go away.
Judge, he couldn't let these people see the car because they could be arsonists. They could set the car on fire and destroy all the evidence of the bad paint job that Bren did. Come on, Judge.
Don't know. I'm just looking out for myself. I should know who he's bringing over to, my mother-in-law's property. I just thought it was fair.
I am never late. I can't be late. I start the stream.
I've tried to work with the guy. I mean, he was the messages. I mean, he was on, let's see, his last response was Friday, February 6th. I mean, I reached out to him. Let me get back there. I
Well,
reached out to him Tuesday, February 3rd. He got back to me Thursday, February 5th, saying that he wanted my address or where the car was at. Okay, then everything he read was our messages back and forth. And I said that's a no on your part of giving me their information. He refused to answer me after that. Then on Saturday, February 7th, I said, I'm trying to work with you, but you're making it way too difficult than it needs to be. Again, I got nothing. Tuesday, February 10th, I said, it's been 3 days since your last response to me. Are you going to work with me or to get this done? So I have been trying. I've been reaching out to him.
Let me.
I just asked him.
One second.
I just asked him. Okay.
Let me address what is allowed here. And we talked about this last time, I guess not quite in this level of detail, but I told you both last time there is a statute that allows for discovery. It includes the right to enter land to inspect property that's at issue. Here it's to either enter land or have the car made available somewhere else to inspect the vehicle that's the subject of the lawsuit. That's 804.09. As I understood it, it was really our discussion on the record was the formal process by which Mr. Dreger was asking for the right to view the vehicle. And I agreed, and you, Mr. McEwen, agreed that you would cooperate. And I agreed that that was a reasonable request under our law that says you should have a right to gather evidence. So what it doesn't say under 80409 is essentially, it doesn't say anything about what detail has to be shared about the visit, other than that you have to describe what item you want to inspect, a reasonable time, place, and manner for making the inspection or performing the related acts, and then the some that only really apply to documents, not to looking at a vehicle. So I do think that in the normal course, when you're visiting someone else's property, you normally will share the minimum details of how many people are coming, what are their names, and what are they planning to do. That's pretty typical, just because you're entering someone else's property. And Mr. McEwen should know what kind of tests they plan to do. If it's just going to look over the vehicle, okay. If they feel like they need to tinker with anything, he needs to be aware of that as well in case he wants his own expert there to watch and inspect at the same time. Mr. McEwen has absolutely zero right to say yes or no based on who Mr. Dreger is choosing to bring. In other words, you are not the person, Mr. McEwen, who gets to decide who's a credible witness, who's a proper expert, who is qualified to look at the vehicle and make decisions about it. You are welcome to argue at court if you think a witness is unqualified, that they don't have the skills or experience necessary, or that I shouldn't believe them. But you don't get to dictate before they even look at it that you don't think that person would be the right person to decide this. So saying that I want to know exactly who they are and be able to look them up and make sure they're a legitimate company, that's not your right, essentially. It's Mr. Dreger's right, and then you can challenge at trial whether or not they were a proper witness. Your other ones are more of drastic worries, I guess I would call them, of theft or arson or things like that. And
Aliens.
my only response on that is, one, we can't avoid, and the court can't plan, and the statute doesn't anticipate the extremely unlikely but most drastic consequences of what could happen, which is that while inspecting property, somebody would commit crime. But we have a criminal system to address that. And if Mr. Dreger was choosing to do something like destroy the evidence while he's there, steal the evidence while he's there, or anything similar, one, that would be very foolish, because we're in this court process. And if I say, if he wants to and he asks, you have to let him inspect, and he comes out and destroys it, then there's all these rules about a party that destroys evidence should be held accountable, meaning that if they make it impossible for the other side to present evidence because they destroy it, I should just hold them in default and sanction them for destroying the property. The other part would be if he comes on your property and commits crime, well then now maybe you add a second lawsuit for destruction of property and the value of that. And now we have more claims for you to bring against Mr. Drager. And in other words, the point I'm making is it would be extremely foolish for him to do that. Not to say people don't
I
do
understand.
stupid things, people do. But you're also welcome, like I just said, you can absolutely be present for the whole inspection. You could have your own expert. That's actually very typical when people, each side has an expert, is for everyone to look at the same time. And, or you could just have somebody there to preserve the peace kind of thing, including if you wanted to potentially videotape the whole interaction if you felt that was truly necessary to make sure you're safe. I don't think you're entitled to videotape Mr. Drager getting opinions on the spot from his expert. But if you just want to videotape to say, if you guys are going to do something wrong, I'm going to catch it on video, that might be a very reasonable precaution to take. So the last time we were here, everyone was cooperative. So I don't think I formally ordered you, Mr. McEwen, to submit the vehicle to inspection. I'm going to formally order you to do that today. If you don't, or if you unreasonably refuse to agree to the time and place, then that would have violated an order to allow inspection, and then I could grant what Mr. Drager asked, which is under Chapter 804. Once I've ordered you to do something related to discovery, if you don't follow my order, then I can dismiss your case with prejudice for that failure. So we're not there yet, Mr. Drager. I have to warn Mr. McEwen and order him to comply before I could just dismiss his case. But I'm going to order him to do that right now. And I have just advised him that if he doesn't cooperate now, I will dismiss. And my order is going to be that unless you, Mr. Drager, need more time because your person can't be available, that he, Mr. McEwen, has to make the vehicle available for inspection by no later than March 31st, 2026. Unless, Mr. Drager, you'd like me to put it as a shorter date, a sooner date.
It's going to be extremely difficult to try to convince these gentlemen by the 31st of this month, if I can even convince them to even want to go look at this vehicle at this point. I mean, they've all tried so much to make this work the first time. I don't know if I can convince them to come back out.
Well, I don't know what that means. What did they do to try other than talk to you about a date and time?
That's what we did. We all collated a date and time. I mean, we all set aside time in our lives to do this, and he pulls the plug at the last minute on us. We can't do it.
Well, it sounds like it was never actually agreed upon what time and day. So
Oh yeah, it's right in here. All the date and time was all set in our written notices. We
okay.
had an exact date.
Well, I'm going to order it by either March 31st or the soonest date after that you and your expert need. In other words, Mr. McEwen has to make it happen as soon as possible. If you need more time because you can't get somebody in there, then I will allow you more time. If we get back together the next time and you can prove to me through whatever it might be, texts or bringing a witness or something, to say, I can't get anyone to agree now because this was such a problem, and that they're willing to say under oath that they agree that they've refused now to get involved because clearly it's too contentious or too big a headache for them or whatever, then I may reevaluate it, because at that point, if it's prejudiced you in your ability to present a defense, I may have to make some orders because of that, which could include dismissal.
Yeah, that sounds fair to me, because that at least I can bring that to these witnesses as well, explain that to them. And that could be persuasive to get them to agree to come look at the vehicle.
Yeah.
That would be a wonderful.
Okay, and the converse of that is if they would come and tell me you convinced them to say it's going to be too big a headache, I won't do it because Randy kept saying it's going to be a nightmare. McEwen might sue you. You know, if you make comments like that, then that would be a problem for you.
Yeah,
okay.
well, yeah, that would be foolish.
And I'm not suggesting you would, but I just want to make sure we're all on the same page. Mr. McEwen, do you understand what I'm ordering today?
No, I do, and I just thought it was obviously I don't know the law, but my thoughts were, why couldn't I have the gentleman's names? Just
And I am going to put that in my order
They count votes. They count.
that
Yeah.
Mr. Drager has to tell you
So-
the number of people coming and their names.
That's all I asked for. That's all I asked for. And
Well,
he stopped
Mr.
communicating
McEwen,
with
even when
me,
I asked
so-
you, you made it sound like you wanted to evaluate their qualifications and all sorts of other things about the
just wa-
people.
I just want to make sure they were legit. That was all. I just wanted to make sure that they were
I
a
hear you, and I'm
reputable
telling you,
person.
that's more than asking for their names. That's asking for their qualifications, their credentials to come look at a vehicle, and you don't get to do that.
Okay, I honestly didn't know that. So, I mean, if I would have known that, I want to get this over as much as Randy does, as much as you do, sir.
Sure.
So, it's been a long time. So,
Okay.
December 15th, 2023. So, I just wanted.
December 15th, 2023. These two have been arguing about this paint job on his car. He says, I just want to get my car painted. He says that right now. Like, this is going on since 2023. His car still isn't painted.
Get this done. I want to get my car painted. I want to enjoy it. So
I want to enjoy my car.
I mean, if I have expert witnesses. If Randy can't get his people, I can get these people to come and he can come and listen to their expert opinion on it. They're
That's
in the
up
body
to
shop
you.
business.
If you wanna tell him when your experts are gonna look at it, you don't have to, but if you want to, you can. So I'm gonna issue that order. I'm gonna put that March 31st date. I'm gonna say that Mr. McEwen will only need to be told the number of people and their name, that he's entitled to be present and supervise, but not interfere with the inspection. And then that he can bring his own experts if he chooses at the same time or whenever he wants, because it's his vehicle.
No. T, don't listen to him. Gene's head will get real big if you start paying him any attention.
Let's pick a day and time for our trial as well. And that way, I know that I'm not going to be able to get you on until May or June anyway, and I don't want to keep kicking it further down the road. So let's just pick that today. Do both of you think a half day, which is about 3.5 hours, will be enough time, or do you feel like you need a full day?
Trial?
For the trial, where you're going to testify and you're going to bring any witnesses or written opinions that they give you about what's wrong.
Well, I think a half day should be plenty.
Mr. McEwen, do you agree?
Yeah, I believe half day.
Okay. Ashley, do we have a half day in May or June?
Look at them
We could
agreeing.
do Thursday, June 4th at 8:30.
Mr. McEwen, does that work for you?
Yes.
And we'll be
June,
in
you said
person
4th?
June 4th, yep.
My
You
name
said
is Bill
8:30,
Henderson.
Ashley?
Margaret.
Yes.
Bill Henderson.
Okay,
That's
so
me.
it'll be in the morning. That'll be in my courtroom at the courthouse. Mr. Drager, does that work for you?
Yes.
Okay. And that'll be the day, if you're going to bring any live witnesses to testify, that they need to be there that day as well. Either in person, or I allow other witnesses beyond the two of you to be by phone or by Zoom. If you want them to be by phone or by Zoom, you have to just let us know ahead of time so we can arrange for that, or at least be prepared to get our Zoom up. And you have to be able to get them the Zoom information. If you want them to just be by phone, as long as you bring their phone numbers and that they promise they'll be around to answer the phone, we can call them from the courtroom.
Because that
You
works
need
great.
to bring any papers you want to show me, anything at all that relates to this. Bring 4 copies of any kind of paper, one for yourself to keep and talk about, one for me to look at.
Bill Henderson, he does American Courts, the channel the excellent, very entertaining channel American Courts. That's Bill Henderson.
One for the other person,
stole his name.
meaning Mr. McEwen or Mr. Drager. and then one for the witness if there's going to be a separate witness to talk about.
Champ Henderson.
Any questions about that, Mr. McEwen?
No, 4 copies of pictures and everything, right?
Yeah, exactly.
Okay.
And that would include if you're going to have an expert write their opinions down and not testify, which can be allowed as admissible evidence in small claims, you would want to bring 4 copies of that.
Mr. Dreger has a copy of the envelope or the folder. Is he still going to bring that with him?
Mr. Dreger, do you know what that's referring to?
I could not understand him.
Our first court date, I had a.
Back in 2023, he gave you a piece of paper, sir. Are you going to bring that with you?
Folder with pictures and statements and all that. And I had one for myself, the courts, and Mr. Dreger. And Mr. Dreger took that one home with him. Is he going to bring that with him?
Do you still have whatever documents those were?
I like that name, Dreger. Mr. Dreger.
Or Mr. Dreger?
I have no idea if I have them or not at this point.
Plan to bring new copies, Mr. McEwen. I'll say I don't have them. The commissioner didn't upload exhibits from the hearing.
Yeah. He gave those back to me, but Mr. Dreger took the folder with him. So
well, just plan to bring additional copies for Mr. Dreger, okay?
Okay.
And Mr. Dreger, you'll do the same. You'll bring copies of everything, 4 copies. And then that should give us plenty of time for you to get your inspection done and get those opinions if you're going to use them. All right. Any final questions about my orders today or trial, Mr. McEwen?
No, sir.
Mr. Dreger?
No, thank you.
Okay. Thank you both. I hope you have a good day, and I'll see you in June.
Do you think McEwen is Scottish or Irish? Or is it both? Is that a dumb question? All right, we got one more clip. Actually, I have 2 more clips, but we ran out of time to do the second one. It would take us well past 2 hours if I did the second one. So we're just going to do the first one, and you're going to love it. You're going to really like this clip. Whoops, if I press play.
Stubblefield, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
What is your name, sir?
Stubblefield.
Mr. Stubblefield, how old are you?
25.
Do you understand English? Are you under the influence of any drug or alcohol? Do you have any mental or emotional disability? So we were going to have an evidentiary hearing on the 11th notice of violation of pretrial release. But in the meantime, there was a 12th petition that was filed. And just kind of going back.
I just went to put my hands up to show you how many 12 revocations are. Then I remembered I can't show you 12 revocations on my hand. And I just lifted my hands up to show you how many revocations he has. Probation revocations.
To, I think, the 10th, and then the 11th, and now we're going to talk about the 12th. On the 10th, I had said I'd had enough, and I made you do a weekend in the jail, which I think you did, as ordered. And then on the 11th, which was 2 weeks ago, on March 3rd, then I told you then that if you tested positive again, that you were going to do a month, because you don't appear to be.
When did I test again? Positive on the 12th.
Well,
when was my 12th amendment?
I'll tell you exactly when it's alleged that.
I deeply apologize. When I edit these videos, take out phone numbers and all the blank spaces and everything, I do it on a faster speed so I can get through them quicker. And it sounds like I maybe forgot to slow it back down to normal before I exported it. I'm sorry. You guys just gonna listen, try to keep up. You can do this. You can.
And that there was a sample collected. Well, let's do this. On March 16th, which is today, the state of Indiana filed a 12th addendum to the notice of violation of pretrial release. The 12th addendum means that it's 13 times that they've alleged that you've violated pretrial release. So Ms. Poulos, well, here, I tell you what, I'll read it. So what's alleged in the 12th addendum to the notice of pretrial release is this, is that the probation department by pretrial officer Erica DeMoss requests the court consider the following information in addition to the notice of violation of pretrial release previously filed on November 22nd, 2024. The defendant has a hearing scheduled for today. And the pretrial release officer alleges that the defendant has violated the following conditions of pretrial release in the 12th addendum to the notice of violation of pretrial release. It's alleged that you violated pretrial rule number 6, which states, I will not use or possess any controlled substances and or illegal drugs unless first prescribed by a licensed physician. If prescribed a controlled substance, I will provide verification to my pretrial officer. I may be required to submit to random drug testing pursuant to a court order. And then it goes on to allege that the defendant tested positive for an illegal drug on March 11th. What the attachment then states is that the individual testing report was prepared on March 12th. And it says that there was a sample collected on March 11th and that you tested positive for cannabinoids and THC once again.
Cannabinoids. Most of us call that weed, but we can call it cannabinoids because you're the judge. I just put my link to Discord in chat. Come to Discord, guys.
The significance of the date then is that was collected by a urine sample allegedly on March 11th. The last time I saw you on the 11th notice of violation of pretrial release was on March 3rd. You allegedly tested positive for the 13th time.
Oh, 12th.
12th addendum, you had a first violation and then 12 addendums. Well, let's just say 12. I'll give you that. It's 12 rather than 13. But that test was 8 days after you had just tested positive again. So, you know the rights, but I will still advise you of your rights because, as you said, we've done it 12 times in a petition in a notice of violation of pretrial release. You're entitled to rights and you're entitled to a hearing. And you're entitled to an evidentiary hearing to determine whether or not you should remain free or have your bond revoked and taken into custody. So,
if I may, Your Honor.
Go ahead.
Thank you, sir. Judge, just for the record, we'll deny the inner denials of the allegations in the 12th addendum. And I completely understand what Your Honor is thinking right now. And based upon the admonishment that you had given Mr. Stubblefield that if there was a 12th addendum, then there would be repercussions and ramifications of that. But Judge, I'd like to, for the record, go through the last 4 tests dating back to September 29th of 2025. When we look at that test, the levels, and I'm sorry, I don't have the.
So let me ask you a question. How long does THC stay in your system?
Judge, Mr. Stubblefield has been an avid, significant daily user of marijuana for a significant period of time. And while I do not have the science behind it, and I know that stereotypically the standard is 30 to 45 days that it should stay in your system. For avid users, it is significantly longer. Now, I don't know the science behind it. I don't have the pedigree to testify or to advise the court of that time frame. But by looking at the different results, Judge, the levels are significantly going down. Back in September of 2025, there were 1,062 and 482. Then there was a test that was collected on December 4th of 2025, and no levels were associated with that test. Then the test that was collected on February 12th of 2026, the levels were 424 and 172, significantly down from the 1,062 and the 482. And then the most recent results, Judge, is March 11th of 2026, and those results were 383 and 113.79.
383 and 113.79 is not zero. It's just not a 0. So, Lightfoot, it's so good to see you.
Again, down from the results that were indicated in the February 12th test. So it's clear, at least it's clear to me, or the argument would be that it's clear that Mr. Stubblefield does not continue to use, because if he continued to use, then those levels would be up or would increase, and they are decreasing each and every test. And so while it's still in his system, respectfully, at least for probably the 10th, 11th, and 12th, I am confident that he is not, in fact, using marijuana or THC that would ultimately violate his pretrial release.
Well, I know one thing. I know that I haven't seen a result where it says his score is 0.
That's correct.
Well, I wouldn't see one where his score is 0, because if his score was 0, they wouldn't be violating him. But on the other hand, if he had scored 0 between last September or whenever it was when I first started testing him, he wouldn't be testing positive now unless he's used since. And I understand your argument to be that his numbers are going down. It's kind of like in a DUI, your body metabolizes alcohol. But I agree with you, Mr. Brown, that you're not an expert on how long marijuana stays in your system, and we don't have an expert here today. But I'm sort of an expert on my memory of what I said 2 weeks ago. And what I said 2 weeks ago is if you test positive again, you're going to go back to jail. I gave Mr. Stubblefield the time to report to the jail the last time, and he did, which I appreciate. But 12 times is too many. At this point, I'm ordering Mr. Stubblefield taken into custody, and he will be held pending.
Like, I'm really trying, sir. Like, I haven't been smoking and using. Like, I don't need jail time. I need help. That's what I'm trying to get y'all to understand this whole time. I need rehab or something, not jail time. My January test is negative. I don't see how I have to go to jail. That's not helping anything. I need help. Y'all saying everybody else to respite houses and rehab, but I got sent to jail. I'm not having any trouble. I have no FTAs. Like, why do I have to keep going to jail, sir?
Because you keep testing positive.
I haven't.
That's why.
Your Honor, I haven't used. That's what I'm trying to get you to understand. I might be around it, but I haven't used myself. I don't see how jail is helping me. That's not helping me. My January test was negative. I don't see how I keep.
Your January test was negative. Is that what you said?
That's what you told me. That's what Erica DeMars told me. Yes.
So that means you've used marijuana since?
No, sir. I've been around it, but I haven't used it.
Your Honor.
Go ahead.
The January test was in fact not negative. It just had lower THC results, so we did not file a violation on it. Then the next test had increased levels, so that's where that February.
More of the story. I'm not using, sir. I don't think jail is not going to help me. I need help.
You do need help, and you're not learning. I just sent you to jail for a weekend.
You gave me jail time. That's not helping, sir.
Well, you're going to jail for longer now.
Mr. Stubblefield, this isn't helping.
Here's what we're going to do, Mr. Stubblefield. The longer you're in jail, then you'll get clean.
Because, sir, how does jail time help you? It's people that get caught with fentanyl, all types of stuff, but get sent to respite houses. Why am I going to jail, sir?
Stand up.
This is crazy, bro. Like, come on now, because I'm going to jail. I haven't did anything. My dad is dying. Like, bro, I'm going through it. Y'all going to take the bill? I haven't done nothing, sir. Yes, my mother needs me. I have a daughter. I work. Like, come on, sir. I don't need jail time, so I'm begging you, sir. I'm really begging you, sir.
You know, stop for just a second. At your 10th time, I sent you to jail for the weekend, and you didn't learn. So how come we're not going to have an evidentiary hearing now? How far out should we go, Mr. Brown?
Judge, I'd ask it, if we can go set it to March 30th, please, if you have some time on the calendar for March 30th.
I'll see how just comes.
This matter is set now for status, March 30th at 9 o'clock. You can take it into custody now, sir. That will be all. Thank you, Mr. Brown.
He needs help, Judge. He needs help. Listen, if the judge tells you in September of 2025 that if you smoke weed, you're going to jail, and then you do smoke weed, and then you do go to jail for the weekend, and then you continue to have weed in your system, that's on you. He says, I didn't smoke, I was just around it. That's on you. You can just not be around it. You really can. Yeah, I can't keep it at that speed normally, Sherry. I would love to. I mean, we would get used to it, and then every court case we watch forever would be boring because it would be on the wrong speed. All right. Just listen, I am not a scientist. I'm a data scientist, but not a real scientist. If you stop smoking weed in September of 2025, it's out of your system by March 9th of 2026. It is, because the internet says so, and the internet doesn't lie. And if your numbers go down, and you are not smoking weed, they do not go back up again out of nowhere. They don't. So, he did do what he said. Alright, guys. We made it to the end. I'll play the clip, the next clip I had tomorrow, because it's like 35 minutes, and we would be well over. And that's it. I'm done. I'm spent. So, I shall see you all again. What is today? Today is someday. Today is Thursday, guys. Yes, I have off work today. I'm gonna sleep. Listen, I am so good in bed. You have no idea how good I am in bed. I can stay there for all day. I can just stay there all day long. All day long. That's what I'm going to do today. So, thank you for coming out. I really, really, really appreciate it. V, thank you, thank you, thank you. I will see you all again tomorrow, Friday. Well done, champ. Well done. Behave, be good, be nice to people, because everybody's going through a shit ton right now. So just be nice to people. I'll see you all again soon. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace, come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. Thank you.